We're staying on top of breaking news right now in Portsmouth, where the jury recommended a sentence of 2.5 years behind bars for former Portsmouth police officer Stephen Rankin. This is a live look over the courthouse from Tower Cam 10.
Now, earlier, the jury convicted Rankin of voluntary manslaughter in the death of William Chapman II. As Deanna said, this is a live look outside with our Tower Cam 10. But joining us now in studio is our Andy Fox.
And with Andy are Rankin's defense attorneys Nicole Belote and James Broccoletti. So, Andy, I want to send it over to you with some more reaction to this sentencing.
Deanna
and the
Laura,
verdict.
Thank you. What Deanna said, what's your reaction? You got manslaughter. I know you're not happy with that.
Absolutely not. We are quite disappointed, but we do appreciate the diligent work that the jury did, that they took their oath seriously, but it's unfortunate that they came back with a guilty verdict for voluntary manslaughter.
I know you weren't in the room, but what do you think it was that took them from a hung jury to manslaughter?
I would only be speculating. The unfortunate piece of it is they weren't able to get the whole story, to hear everything about Mr. Chapman's background, his history, and his character.
And James, you were talking outside previously, and this will be going to appeal. When you appealed this, what are the 3 things that you want in evidence that were not allowed in this case?
I think you start with, as Nicole indicated, I think the jury should have been told about the past record of Mr. Chapman. We believe that was admissible to show his violence, his turbulence, his aggressive behavior, and Virginia law allows that in a self-defense claim. Number 2, we think that the jury should have been able to view the contents of the backpack that he had that was on him at the time.
For the folks at home, tell what was in the backpack.
Well, I'm not able to talk about that because the court excluded that from evidence, and so that has been sealed for some appellate court to review. But
Number 3?
We think that would have been significant. Number 3, we had an expert that was prepared to testify about various what's called use of force and factors in police training and experience, and the court excluded him as an expert.
And what would he have said?
Well, as we told the court, he would have talked about the use of force continuum. He would have talked about the methods that the police officers go through in their training. He would have talked about the different levels and what they call a ladder of use of force, how you start at the bottom and work your way towards the top. He would have had a great deal of things to be able to explain to the jury that the jury wasn't aware of, or that we're all not aware of from a common knowledge standpoint.
Other than getting that evidence admitted as part of this case, what is the one thing that you regret the most, and obviously not the sentence, about what happened during the trial that if you could have a do-over, you'd do?
Well, from an evidentiary standpoint, I can't say that we would have changed anything other than the evidence that we had come in. There were issues with the juror and the conduct there that concerned us greatly.
And also, you got a jury instruction for manslaughter. You did not want that. You wanted first and second degree, and you knew going in that there was not going to be any premeditation or malice.
Well, the Commonwealth's attorney decided to seek an indictment for first-degree murder. We thought that if that's the indictment she sought, that's the indictment that the grand jury returned, that's the evidence that she presented, that's what the trial should be about.
Obviously, that was the biggest loss you had in this trial, to have that as a jury instruction of manslaughter.
Well, we objected to that. The Commonwealth's attorney asked for the lesser-included offenses, is what they're called, second-degree murder and voluntary manslaughter. We objected to that, again, thinking he was indicted on first degree, he should be tried on first degree.
2.5 years he got. Tell me about your client. What's his mood? What was his reaction? What has he told you privately?
Well,
we can't tell you what he told us privately.
Absolutely.
Go as far as you can, counselor.
He's obviously devastated. I think that's to be expected, but he's ready to.
Was he
to
surprised?
We prepare for everything, prepare for the worst, but
he was going down. 1, 2. This is what I did when I got there. Then it got more, and then I went this. It was a chain of command, ending with the lethal force that he needed to do.
It is absolutely unfortunate.
That was a powerful part of your presentation.
Well, it's like we told the jury, people had choices to make. Some parties made choices that led to some decisions and some conclusions. Mr. Rankin made choices that were based upon his training and experience, and he followed the training and experience from start to finish.
Okay, October 12th, you have a formal sentencing on October 12th. He remains out on bond pending that sentence that will be coming up, and that will be the official sentence. Nicole Belote, James Broccoletti, thanks so much. I know it's been a tough day, tough week. Thanks for coming by. That's the latest. Guys, back to you.
Thank you.